We begin with breaking news from Lansing in Michigan's recount battle. A key hearing happening right now to determine if the recount continues. As recounts began in Wayne and Macomb counties and continue in Oakland County today, Donald Trump and his Republican forces are fighting to have those recounts halted on two fronts.
They are appealing a federal judge's ruling that the recounts must proceed and also taking their objections to the State Court of Appeals. Let's get to Guy Gordon in Lansing tonight, and Guy is live. Guy, that hearing was scheduled to start about 4 o'clock. It's still going on now?
It certainly is, Kimberly and Steve, and it all comes down to the definition of one word, that word being aggrieved, a word that was drafted more than 100 years ago when this election law was written. And what justices, or the judges in this case, are trying to determine is what those legislators meant. What was their intent? Jill Stein says that she was aggrieved by unspecified mistake or fraud in this election. Here's what the Trump forces are objecting to with that. They say that she cannot be aggrieved under the definition because she has no chance of winning. Only had 1% of the vote. Also, they say she must provide evidence. And the statute does say it, quote, must set forth as near as possible the nature and character of the fraud or mistakes alleged. But the forces for Jill Stein say that the law is silent on the margin of victory or loss, that doesn't matter. She just must make an allegation of impropriety. And that evidence is not mandatory because the statute also says, quote, the petitioner is only required to allege fraud or a mistake in the petition without further specification. Here's the crux of their arguments.
If there's information they have that there's been large-scale hacking that could have changed the results of our election, don't you think that the Board of Canvassers would be interested? If they have facts of that basis, don't you think that the Board of Canvassers would want to investigate that? But it wasn't included in the petition.
But respectfully, this court has no authority under the Supremacy Clause and binding precedents of the United States Supreme Court to interfere in any way with a federal court order.
And that is one of the big issues here. If this court puts forth a remedy, will it be in conflict with the federal court, and who has precedence there? It does appear that the Mark Goldsmith decision of Sunday night did leave the door open to another decision. And even Peter O'Connell, the presiding judge in this case, said that that was a very narrowly focused case, looking only at the 2-day delay and whether or not they had to move forward. They did move forward, but that doesn't say that it couldn't be stopped. At least that was what he was suggesting from the bench. They are still going with those oral arguments. Another major development today, Attorney General Bill Schuette did join the appeal at the appellate level for the federal decision, saying that the federal courts have no jurisdiction to meddle in Michigan election law. So that's moving forward. This will move forward. If there's a decision, we'll get back to you right away. That's where things stand right now from the Court of Appeals. I'm Guy Gordon, Local 4. Kimberly and Steve, back to you.
Guy, nobody wants to go out on a limb and carve new legal territory. So is there some case law that gives the panel precedence to lean on?
Absolutely none, Steve, and that is the problem. We've got 100 years of election law, but any case that approached this nature of what is aggrieved has always been in a race where there was only that much difference between the two candidates, where there actually was a possibility of changing the outcome. She would have to get a 2 million vote change here. There's no possibility of that, so we are in uncharted waters.
Well, I guess there's been a lot of precedent set in this election year, so this continues it. Thank you, Guy.
To say the least.
What a year, huh?